Gonzalez v. Carhart doesn't take place until 2007. Justice Kennedy writes the majority opinion in a 5-4, again, closely decided case. Um, so to give the background right off the bat, in passing the Partial Birth Abortion Ban Act of 2003, Congress responded directly to Stenberg, the previous case, in two ways. First, Congress found that there was a moral, medical, and ethical consensus that partial birth abortion is a gruesome and inhumane procedure that is never medically necessary and should be prohibited. Important finding. Second, the Act's language differs from that of from the Nebraska statute that was struck down in Stenberg. Among other things, the Act prohibits knowingly performing a partial birth abortion that is not necessary to save the life of the mother. The Supreme Court, unlike the previous decision in Stenberg, holds that this law is not unconstitutional. And the argument that Justice Kennedy makes in the majority opinion is that Casey sets a standard that a woman's interest in ending her pregnancy can be balanced against the state's interest in protecting, promoting fetal life. The statement about protecting fetal life changes the tone of the abortion debate, since the Supreme Court in Roe and other cases said that there was no judgment on when life begins, and whether fetal life is different from life is an extremely fine distinction. But in this case, in the Supreme Court case, the state seems interested in that change of the tone that was in the law that Congress passed. In fact, the Supreme Court talked about a woman's mental health, which has never been part of the debate before Gonzalez v. Carhart. In fact, they discuss a woman's mental health with regards to abortion by saying, quote, "Some women come to regret the choice to abort the infant life they once created and sustained." This had never been introduced into these sort of debates before, and it seems that it particularly was persuasive, at least for a majority of the court. So in the end, the court holds that the federal ban on what is known as partial birth abortion is constitutional. It doesn't overrule Stenberg, which it could have, but it very clearly goes in a different direction than Stenberg did. So why 7 years later is this case decided in a very different way than Stenberg v. Carhart? And the answer to that is exceedingly simple, and it's the answer that most often is the case when we see drastic changes in Supreme Court jurisprudence in just a few years, and that is because of change of personnel in the court. In this case, Justice Alito replaces Justice O'Connor. Remember, Justice O'Connor is in the majority in Stenberg. She drafts the opinion in Casey, and her replacement by Justice Alito, someone who is more conservative than she is, switches the decision from Stenberg, in which she was in the majority, to a decision in which her replacement, Alito, is now in the majority in Gonzalez. And in this context, that personnel change is the majority opinion of this court. Obviously, there are some significant dissents. It will not shock you to realize that Justice Ginsburg writes one of these dissents. She says that the majority in this case blurs the line between pre and post viability abortions. And for the first time, it approves a ban on an abortion with no exception for a woman's health. She says, she continues on about how she is alarmed. She's a supporter of abortion rights, never truly was a fan of Roe, or at least the way that the Supreme Court cobbled together the decision in Roe. But she still feels that the Supreme Court has gone back on that precedent and turned their back on it, and her dissent makes that exceedingly clear. Perhaps her strongest point is when she questions the paternalism of the Supreme Court and Congress in their quest to protect women's mental health by denying them the right to choose for themselves in order to protect themselves from their own choices. She writes, "Because of women's fragile emotional state and because of the bond of love the mother has for her child, the court worries doctors may withhold information about the nature of the intact D&E procedure. The solution the court approves then is not to require doctors to inform women accurately and adequately of the different procedures and of their attendant risks. Instead, the court deprives women of the right to make an autonomous choice, even at the expense of their own safety. So she seems quite interested in that the court and Congress, as an extension, is now interested in the emotional state of the woman and her child. And they're so interested in that emotional state that they deprive the woman the ability to make her own autonomous choice. So her dissent is it's very very poignant and gets to the an interesting point with regards to the outcome. Understand, however, Roe is still good law after this. Roe is not overturned. Abortions are still legal. And states still must allow abortions to continue, just not this particular procedure that is banned in the Partial Birth Abortion Ban Act. And I have in my notes from when I wrote this that it's not clear, given the ideology of the court, and I was writing this in 2010, how long that will exist into the future, how long Roe will remain to be good law. Well, now we're sitting here 13 years later, and Roe is still good law. And the court is more conservative. And so to me, it still remains unclear how long it will take, if it will ultimately be struck, the decision in Roe will ultimately be struck down. But the precedent has proved interestingly resilient in the face of a court that, at least facially, at least ideologically, should be predisposed to do away with that precedent. It has somehow survived lots of different courts. So remember, we talk about individuals as early as the 1980s thinking that the decision was that Roe v. Wade was going to be overturned. It didn't happen. And then we're still talking. We talked about it in the 2000s with the addition of Alito to the court, and it didn't happen. And we're looking at a court now where it's, granted, the issue hasn't come up yet with this new court, but Roe has remained very resilient. And I wouldn't want to be one to forecast its death, because it doesn't seem clear at all that anyone who has forecasted Roe's premature death has been correct.